is in there that the governor proposed?
I believe the number that I have, and I'll have to double check that, it was 15 million that was appropriated. I believe around 20 million would bring us up. And again, it's not going to solve it, but it's at least going to, in my mind, 150,000 miles on a car is way too much. And if we can replace that 20% above that, that should at least make things a little bit safer. And as the superintendent said, it might be a 2-year solution to this problem. And then next year we can whittle away at those other cars. But that $5 million would be on top of the appropriation, which I believe is 15 million instead of the 18 million.
Okay, thank you. Thank you for the work of you and your members to keep our community safe.
Thank you, Chairman.
Thank you very much.
Thank you.
Next is the police conference in New York. Richard Wells.
Good afternoon. We're going to make it brief also because we know you've been here all day. My name is Pete Paterson. I'm the legislative chairman for the New York State Association of PBAs. I'm also vice president with the Nassau County Police Department.
Pete, could you pull your microphone closer to you? Closer, just pull it close.
I have also with me Rich Wells. He's the president of the PCNY. He represents over 25,000 active police officers from Montauk to Buffalo. We appreciate you giving us a little bit of time to speak on Senate Bill 2011, which is in the budget, with the use of force. It's a statewide use of force policy. My association and Rich's association, we have a concern. We have two major concerns with it. One concern we have with it is the way the legislation is written is if you adopt this law as such, you're opening up a point where you're adopting a blind policy. You're giving the state, you're allowing the state to mandate a policy which may or may not be good. But the problem is we haven't seen the policy. We couldn't even say if it's good or bad policy. We have a lot of police commissioners and sheriffs throughout the state, and like my department, we represent 2,500 members, and Suffolk has approximately the same. They would have to adopt a policy without our commissioners, our chiefs getting involved. And once again, it may or may not be good, but I don't believe adopting a law with a blind policy it would be good at this time. The second issue, and probably more importantly, is opposing any standard that categorically rules out any particular mode or technique of force, regardless of circumstances. We believe is inappropriate. What happens? Article 35 of the penal law allows us to use deadly physical force in certain circumstances. Actually, it also allows civilians to use it under certain circumstances. When a police officer is faced with that, it's often within seconds. He's got to make a critical decision. He's got to be reasonable, and it's got to be necessary. And he will be judged when he's done doing it. He will be judged by the department, by internal affairs, CCRBs, grand juries, district attorneys, and such. And rightfully so. We must prove why we did it, and we have no problem with it. The issue we have when you have to use the use of deadly physical force, it's often, like I said before, often within seconds. To have a technique or mode strictly prohibited is going to cause our officers to step back a bit, and it could cause a fatal result to either the officer or a civilian, innocent civilian, a third person standing by. You know, we use this example. I mean, like I said, you legislators are allowed to use deadly physical force under certain circumstances. You walk into your house and you see one of your loved ones getting ready to get stabbed to death. Reasonable and necessary, that's what you need to do. Is it reasonable to stop it? Yes. What necessary force you're going to use? Well, you're going to use pretty much whatever you can to stop it. You don't want to sit back and say, this technique might not be a good technique, that technique not be bad. You are going to be judged by reasonable and necessary, and we don't feel that it should be limited. Article 35 was written in that way. Article 35, if you look at it, it realizes that not one size fits all, particularly when something is as serious as critical as the use of deadly physical force. We have a couple of other issues we'd like to speak to. I'll turn it over to Rich Wells from the PCNY.
Good afternoon. One of the other issues is the independent monitor
Under this legislation, if a police officer uses deadly physical force against an unarmed subject and a grand jury does not return a true bill of indictment, the governor will appoint an independent monitor who will serve for a 3-year term. Now, that independent monitor, first of all, will not be independent. It's a political appointment, which means there will be a political review of a district attorney's integrity. District attorneys make their decisions whether to put something to a grand jury and how it's put to a grand jury based on evidence and fact, not on public opinion. The other problem is this section treats police officers differently than the rest of the citizens of this state. It removes DA prosecutorial discretion during the process of deciding not to present to a grand jury, and the bill as written would include a very broad number of cases because an unarmed subject is not defined, nor is an armed subject defined. And you cannot find a definition of either of those in either the penal law or the criminal procedure law. It's just not there. So what is an unarmed person? We don't know because the bill does not specify. Grand jurors, not district attorneys, hand down decisions. This bill would second-guess the existing jury system, one that has been placed for a very long time. The monitor considers 2 issues: evidence not presented and new evidence. Current law provides that a judge can cause a case to be presented to the grand jury again if these issues exist, thus negating the need for a special monitor. It has reporting requirements that all local police agencies will have to now conform to, including on any summons issued to ascertain the race and the ethnicity of the person stopped. That's going to cause needless confrontations out on the street. We're trying to reduce these tense situations. We don't need to exacerbate them with reporting techniques such as this. A couple of general points. We question why this is even included in the budget. The only expense contemplated by this bill is for the compensation of the special monitor. When you look at the entire New York State budget, that is so minuscule, this should really not be part of the state budget, this bill. Secondly, up until the fall of 2014, there has never been any outcry that I'm aware of or anyone in our organizations are aware of to reform the grand jury system. It's functioned for over 2 centuries. And now critics are calling it antiquated and it should be completely revamped. We don't see where that's necessary. Cops lose cases in the grand jury all the time. They spend their time with prosecutors putting cases together, and sometimes juries come back with no true bill. That's the way it is. That's the system. You're frustrated with it, you're disappointed, but you move on and you go on to the next case. The system is not broken. One controversial finding by a grand jury is no reason to change what has served this state well for many years. Thank you.
Thank you, gentlemen. Senator Nozzolio.
Thank you, Senator. Good afternoon, gentlemen. Just because the hour is late doesn't mean that this issue is not of critical importance to the future of the state. That normally we're visited by police officers and discussing issues from various police departments. I speak for upstate. This year, there was one issue on the minds of those officers, and that's the issues that you're addressing today regarding treating them as second-class citizens, establishing a infinite tail onto the proceedings that have no end, which in and of itself creates an anxiety-ridden job with needless anxiety in perpetuity for this case, in this profession. So your comments today are certainly taken very seriously. That we, Senator Gallivan, myself, Senator Golden, Senator Marcelino, Senator Croce participated in, and Senator Lanza participated in a hearing a few weeks ago in New York City. We're going to be having one next 2 weeks in this city, in Albany, in the capital, to look at the entire reform of the criminal justice system or changes in the criminal justice system. But certainly this proposal is one that we have taken testimony from our New York City representatives, and now having your input is extremely important. let's comment, if you would, for a second, on the lack of finality in the process. You've analyzed, you've addressed it, you've analyzed it. Expound upon your opinions regarding what this procedure would do.
Well, what it does is if the special monitor does not agree with what the grand jury did, he then goes to the governor and will recommend that a special prosecutor be appointed. And under current law, the special prosecutor would be the Attorney General. This bill does nothing to change that statute. So the Attorney General then would have to go back, impanel either another grand jury or the same grand jury, I'm assuming, and present the case all over again. So it's, you know, could consider it double jeopardy.
A double jeopardy that...
Well, we've already had a determination by a grand jury that there is no evidence or not enough evidence to go further for a trial. But now we're having a special monitor look at it, and then a special prosecutor, and perhaps a second grand jury impanel.
If I may, the bill also addresses two components when the special monitor can do that, and it's if evidence has not been presented that may or may not, that may or should have affected the outcome of the grand jury, or if you have completely new evidence. And we believe, unless we're told otherwise, that that can be done now as a matter of law, and it can be done in any grand jury. One way we look at it, like you know, I've had 5 police officers killed in the line of duty. The state troopers, unfortunately, have a lot more. If one of, we call them the bad guys, get put before the grand jury and he doesn't get indicted, he walks. You know, it's just, we just want to be treated basically the same as everybody else in the state.
In New York City, in our hearings, District Attorney Donovan from Staten Island indicated that there already is a monitor on grand jury proceedings in the form of a judge. When a grand jury makes its decision to indict, the judge needs to certify that decision. There isn't the identical process when the grand jury indicates it has no reason to indict, or it has not found sufficient evidence to recommend indictment. But that should in itself be a vote that was taken, a vote that's out there, and a vote that was done normal course of business. So your comments, I believe, also could be related to, expand upon them, relating to the issue of having those proceedings be subject to a report, if you will, of the district attorney. Would you further elaborate on your concerns?
Well, one concern with that is that the report will be required if a police officer uses deadly physical force. However, if deadly physical force is used against a police officer, no report is required. So once again, we're being treated like second-class citizens. Also, the police officers' names will be released in any of those reports, but no one else's. In certain circumstances, I should clarify that, other public employees will be.
And I think that your questions about privacy and safety are something that should be also elaborated on. That the placement of an officer's name, address, the names also of witnesses in that type of open process, what does that do in terms of chilling effect for both officer and potential witness?
Yeah, our Detectives Association spoke about it. If it does cause a problem, particularly with potential witnesses, in this circumstances, it's if they have, like, let's say it expands to drug cases or whatever, where you have confidential informants or whatever. Not that you're going to expose their names, but it would have to be done in a way where their identity is, they have enough trouble getting people to come in to testify before a grand jury as it is. So the detectives had concern, the detectives we represent throughout the state had a lot of concern about that.
I think that getting to the issue of the report that a prosecutor would have to establish, the grand jury report made public basically would end any principle of protection, of identity protection And then I think that it may get to witnesses, it may not get to witnesses, but the fact is the danger is always there.
Absolutely.
Well, thank you for bringing this issue to the forefront today. It's an important issue. It's one we're going to have to wrestle with. I, for one, don't believe it should be part of the budget process because it's certainly something that deserves full airing and analysis beyond the budget in terms of outside of the budget, which is normally, as you know, a very intense process in and of itself. The issues here are too significant, in my view, to be put and squeezed and sandwiched between the normal budgetary processes here in the state. Thank you, Mr. Chairman.
Thank you, Senator Nozzolio. We're going to go to Assemblyman Lenthal, then Senator Gallivan, then Assemblyman Saladino. Assemblyman Lenthal.
Thank you very much, Mr. Chairman. Thank you, gentlemen, first of all, for the service that you've given us as police officers for these many years. I certainly respect the way in which you've represented your constituency, just like I try to represent mine. And I thought, I didn't get a chance to hear your testimony, but I looked it over, and I understand the way you feel about the change of the grand jury system, the way in which the governor has presented it in his budget. And I floated a question earlier today with the chief administrative judge, and I just wanted to bounce it off you because everybody who has spoken had talked about the grand jury system, and some of the members here have talked about the antiquated grand jury system that we have in this state that's part of the common law of England. And I wondered if a major change in the grand jury system is in order for somebody to consider, because we've had it for so many years, and maybe we ought to think of a more transparent grand jury, and or maybe even scrapping the grand jury system altogether and not give district attorneys the ability to hide behind a grand jury and have a preliminary hearing in the Supreme Court, Superior Court of the counties, and allow witnesses to be called in a transparent manner. I heard what you said about confidential informants and about other accommodations would have to be made for those type of witnesses. But I wonder if we should bring the system, the criminal justice system, into the 21st century and have a hearing that would have the benefit of allowing transparency in the process by allowing everybody to hear what the witnesses have to say. I don't know if there still exists any reason for secrecy in the procedure, but you know, I'm not a historical expert, but you guys are part of the criminal justice system, and I wanted to get your opinion about it. Because what I'm envisioning is a transparent system whereby witnesses would be heard, everybody could see what the witnesses said at a grand jury, just like you have on court TV. And in by the same token, you would also allow a little bit of discovery to everybody to see what the evidence is against. The prosecutor would be able to see the kind of witnesses and the kind of case he has. The defense would see some of the witnesses and what kind of case is against his client, and it would probably move the wheels of justice even faster. So I'm saying that, I'm preaching, I know, but I'm just trying to, you know, maybe get your take on that.
As I said earlier, Mr. Lenthal, that we don't feel the system is broken. And the history of the grand jury was to protect the individual from being dragged into court by an oppressive government. It goes back to common law in Great Britain, as you said. We feel that it has functioned well. There is no major reason to change it other than there have been a couple of high-profile cases that have been unpopular. But we don't change things based on public opinion. We change them on if there is a need. As far as bringing into the 21st century, it's been modified over the years, but basically it's there to protect the individual. And if you were accused of a crime, but there's not enough evidence to even go forward with a trial, this saves people from having their names dragged out into the public. I mean, again, that was one of the initial reasons for it. And We don't see a need for a major overhaul in it at this time, and certainly not to be done in the context of the time frame of the state budget.
Yeah, that's one of the major concerns. Obviously, we feel it's working, and we don't want to change, but during the discussion that you're talking about, we understand in certain circumstances how people get frustrated. We get frustrated as police officers. We present the case to a grand jury, and they return no true bill. We worked on it for 6 months. We know, we believe in our heart of hearts that that guy was guilty. The grand jury had the luxury of having all the facts and circumstances and all the testimony, and they return no true bill. And we don't get the copy of the testimony. So we understand your point of people being frustrated, not knowing what's going on. But that, like Richie said, that would be a major, major change, a major overhaul. Mm-hmm. And you, quite frankly, again, we're not at that point yet, but you'd have to have law enforcement experts speak on it because, like I stated earlier, our Detectives Association emphatically said they have a hard enough time to present the case to a grand jury in certain cases where people are they're scared. You know that yourself. And one of the components, like I said, the biggest, I guess, issue we have as to start this off with is the change of the grand jury just deals with police officers. It's kind of like we feel we should be treated like everybody else.
Right. I mean, that's the reason I floated that proposal, because it would treat everybody equally. That wouldn't be a grand jury just for police officers. That would be for everyone. Thank you.
Okay, thank you.
Senator Gallivan.
Thank you, Chairman. Good afternoon, gentlemen. Thank you for your testimony. Your points are very well taken regarding the governor's criminal justice proposals that you commented on. There's one other particular area in criminal justice that the governor has put forward in his budget, the concept of whatever we're calling now raise the age of criminal responsibility. There's a number of different points in there. But what my question has to do with is that set of proposals, and what are the implications for the police officers that you represent across the state if the raise the age was enacted or implemented?
Well, you're talking about raising the age, so now we're going to have, I guess it's 2 more ages, correct, that will be considered juveniles and must be charged juvenile.
Well, a series of proposals, but essentially raising the age of criminal responsibility from 16 up several years.
There are 17-year-olds that are children, and there are 13-year-olds that are hardened thugs. Just to blanketly raise the age, I don't think it's wise.
And I appreciate that. Are there any implications for the police officers you represent across the street on a daily basis?
I'm sorry?
Are there implications for the police officers that you represent on a daily basis? Does it make their job easier, harder, communities safer, communities less safe?
Well, juveniles must be treated differently. So depending on the size of the department and many issues like that, but you'd have to have different or more juvenile officers assigned, trained facilities to house these individuals when they're brought in, because there's a separate set of rules for juveniles. So yes, it would cause a major change.
All right, thank you. That was all I had. Thanks, Chairman.
Thank you. Assemblyman Saladino.
Thank you for being here with us today and being so cooperative. My question relates to this issue, which I agree with my colleagues should not be part of the budget. Kind of amazing that instead of talking about dollars and saving lives, we're talking about policy issues that have a place here, but not part of the budget. If this policy becomes law, and we have seen a tremendous change in the way the media reports on stories, and as many of my colleagues know, I'm a former journalist, former broadcaster, a master's degree in journalism, and I'm truthfully amazed at the change in the way in which stories are reported on and the lack of balance as compared to just 20 years ago. We know that, and I think that's something that all of my colleagues from everywhere in the state would agree upon. We see hype like never before. We see the need to sell papers and battle for airtime becoming the predominant issue rather than reporting a balanced story. It's rather amazing. Do you feel, if this was to take place, and in the environment with the media that we know today, that if that if a case has a media charge of just a tremendous amount of hype, would that affect, as we've seen over and over, would that affect the outcome? Would that affect the ability for government to deal fairly and equally with an officer?
Well, like we said before, with respect to the grand jury proceedings, obviously the more you expose or the more open it is, the media will weigh in on it, and people, like I said, grand jurors, police officers, legislatures, we're all the same. We're all people. You know, we could say, you know, we believe in this and we believe in that, and we do, but we're all people at the end of the day, and we have our concerns. Grand jurors are no different. You sit on a grand jury, you're going to come out with a decision that's, and a lot of times, as we've seen, it's going to be a major decision, and it's going to have major impact within this state or within this country. The concern is, yes, the media, being a police officer, they're not really, let's put it this way, they're not really bigger fans of me, but but the media will generate and will ignite the issue, and that's one of the concerns we have with it. I mean, obviously, yes, that would be a concern.
And all of these cases seem to take on a larger proportion of life now because it's a 24-hour news cycle. You know, they have to find something to speak about. And, you know, I go back to the night of the Ferguson grand jury decision. You know, I mean, I was up till 3 in the morning, basically, because I have no life, so I watch this stuff. But you watch Fox News, it was the end of the world as we know it. You switch over to MSNBC, and there was nothing to see here, just move along. So it goes back and forth depending on the media venue. But, yeah, the increased amount of news coverage certainly is going to have an effect on this.
My concern is that with so much bias in the media today, that we would not, in a changed system, that there'd be a big impact on that outcome based on that very biased environment. Well, you've answered my question. Thank you.
Okay. Thank you.
Gentlemen, thank you very much.
Thank you.
Next, New York State Police Investigators Association, Jeff Kaiser, President.
Good afternoon, esteemed members of the Senate and the Assembly. I appreciate your patience. I know this is a long day. My name is Jeffrey Kaiser, and I'm the president of the New York State Police Investigators Association, a union that represents a little over 1,100 investigators and senior investigators in the New York State Police Bureau of Criminal Investigation, more commonly referred to as